Okay, we're going to be reading Landlord Legal Guide, and preparing leases and rental agreements is chapter 2. The only thing I wanted to share from this chapter was the chapter 3, rent control. How much can you charge? Property subject to rent control, limits on rent, legal or just cause evictions, registration of rental units, deposits, and notice requirements, when rent is due, first day, last day, or in between, when the due date falls on a weekend or holiday, grace periods for late rent, where and how rent is due, late charges and discounts for early payments, return check charges, partial or delayed rent payments, raising the rent. So let's read mainly the first section straight through until just cause evictions. To state the obvious, one of your foremost concerns as a landlord is receiving your rent on time and without hassle. It follows that you need a good grasp of the legal rules governing rent. This chapter outlines basic state and local rent laws affecting how much you can charge, as well as where, when, and how rent is due. It also covers rules regarding grace periods, late rent, return check charges, and rent increases. Avoiding rent disputes. Here there are 3 guidelines that can help you and your tenants have a smooth relationship when it comes to the area of utmost interest of you both. Rent. Clearly spell out rent rules in your lease or rental agreement, as well as a move-in letter to new tenants. Be fair and consistent about enforcing your rent rules. If rent isn't paid on time, follow through with a legal notice telling the tenant to pay or move, the first legal step in a possible eviction, as soon as possible. Lease and rental agreements, these are related topics. Provisions relating to rent are in Chapter 2, collecting deposits and potential problems. We just read that from Chapter 4 about last month's rent, and compensating a manager with reduced rent is in Chapter 6. There's some more related topics, highlighting rent rules in a move-in letter to new tenants and collecting the first month's rent. Chapter 7, co-tenant's obligation for rent. Chapter 8, how a landlord responsibility to maintain the premises in good condition relates to a tenant's duty to pay rent. Chapter 9, tenant's obligation to pay rent when breaking a lease. Chapter 14, accepting rent after a 30-day notice is given. Chapter 14, how much can you charge? In most states, the law doesn't limit how much rent you can charge. You're free to charge what the market will bear. However, in some American cities and counties, rent control ordinances do closely govern how much rent a landlord can legally charge. Rent control is discussed in Section B. If you aren't subject to rent control, it's up to you to determine how much your rental unit is worth. To do this, you may wish to check newspaper want ads for rent or comparable properties in your area, and perhaps visit a few places that sound similar to yours. Local property management companies and real estate offices that govern rental property may also provide useful advice. In addition, local apartment associations or other landlords you meet in association functions are a good source of pricing information. Many wise landlords choose to charge just slightly less than the going rate as part of a policy designed to find and keep excellent tenants. As with any business arrangement, it usually pays in the long run to have your tenants feel they are getting a good deal. In exchange, you hope the tenants will be responsive to your business needs. This doesn't always work, of course, but tenants who feel their rent is fair are less likely to complain over trifling matters and more likely to stay for an extended period. Certainly, tenants who think you are trying to squeeze every last nickel out of them won't think twice before calling you about a clogged toilet at 11 p.m. Rent control. What we really want to know about. Unless you own property in California, the District of Columbia, Maryland, Massachusetts, New Jersey, or New York, you aren't affected by rent control. You can skip ahead to Section C. Communities in only 6 states, California, the District of Columbia, Maryland, Massachusetts, until the end of 1996, New Jersey, and New York have laws that limit the amount of rent landlords may charge. No surprise that that's the definition, but laws that limit the amount the landlord can charge. Typically, only a few cities or counties in each state have enacted local rent control ordinances, also called rent stabilization, maximum rent regulation, or similar term. These are some of the state's largest cities. For example, San Francisco, Los Angeles, New York City, and Newark all have some form of rent control. Rent control laws commonly regulate much more than rent. For example, owners of rent-controlled properties must follow specific eviction procedures. Because local ordinances are often quite complicated and vary widely, this book cannot provide details on all the different forms of rent control. Instead, we provide a general description of what these ordinances cover and what you should be on the alert for. If you own rental property in a city that has rent control, you should always have a current copy of the ordinance and any regulations interpreting it. And be sure to keep up to date. Cities change their rent control laws frequently, and court decisions also affect them. It's a good idea to subscribe to publications of the local property owners association and pay attention to local politics to keep abreast of changes in your rent control ordinance and court decisions that may affect you. Know the law or pay the price. Local governments typically levy fines, sometimes heavy ones, for rent control violations. Violation of a rent control law may also give a tenant a legal ground on which to win an eviction lawsuit. Depending on the circumstance, tenants may also be able to sue you. Rent control board. In most cities, rent control rests in the hands of a rent control board. These people, usually no more than 5 to 10 of them, decide about annual rent increases, increased fines, and other important issues. In some cities, members are elected by voters. In others, the mayor or city council appoints them. The actual rent control ordinance is a product of the local legislative body, the city council or county board of supervisors, but the rent control board is in charge of interpreting the provisions of the law, which can give the board significant power over landlords and tenants. So they decide about annual rent increases, fines, and other important issues. They're voted in. The city council appoints them, and the city council or county board of supervisors is from which this arm extends as a local legislative body, but the rent control board is in charge of interpreting the provisions of the law. And the law is the rent control ordinance. If you own rental property in a city that has rent control, you should always have a current copy of the ordinance and any regulations interpreting it. And be sure to keep up to date. Cities change their rent control laws frequently, and court decisions also affect them. It's a good idea to subscribe to the publications and local property owners association and pay attention to local politics to keep abreast of changes in rent control ordinances and court decisions that may affect you. Know the law or pay the price. Local governments typically levy fines, sometimes heavy ones, for rent control violations. Violations of a rent control law may also give a tenant a legal ground on which to win an eviction lawsuit. Depending on the circumstances, tenants may be able to sue you. So, that's one thing we want to know. So one of the inquiries, so I'm preparing a table, and what I might say is legal issues, inquiries, objectives of this memo, and just put together like questions presented. Does Oakland give a tenant a legal ground to win an eviction lawsuit? Not the full question, but does Oakland I'll say for violation of landlord's violation of rent control laws. So the first question actually is Oakland have rent control? And they do. And we'll see. Although San Francisco was named and Los Angeles was named, I believe Oakland has it from the last time we did work there. Now, one, property subject to rent control. Not all rental housing within a rent-controlled city is subject to rent control. Generally, new buildings as well as owner-occupied buildings with 2 or sometimes even 3 or 4 units or less are exempt from rent control ordinances. Some cities also exempt rentals in single-family homes and luxury units more that rent for more than a certain amount. So, what types of property are subject to rent control in the jurisdiction? So, rather than asking simply about Oakland, does the jurisdiction have rent control? What types of property does the jurisdiction give the tenant the legal ground to win an eviction lawsuit for landlord's violation of rent control laws? And I'll just say per the interpretation of provisions provided by the Rent Control Board. Just to include what we're learning here right now. Limits on rent. Rent control ordinances typically set a base rent for each rental unit. The base rent usually takes into account several different factors, including the rent that was charged before rent control took effect, operation and upkeep expenses, inflation and housing supply and demand. The ordinances allow the base rent to be increased under certain circumstances or at certain times. Rent increases for existing tenants. Most local ordinances build in some mechanism for rent increases. There are just a few common examples. Annual increases. Some ordinances automatically allow a specific percentage rent increase each year. At the amount of the increase may be set by the Rent Control Board, or may be a fixed percentage, a percentage tied to a local or national consumer price index, or even a percentage of the tenant's household income. Increase expenses. Some rent control boards have the power to adjust rents of individual units based on certain cost factors, such as increased taxes or maintenance or capital improvements. The landlord may need to request permission from the rent control board before upping the rent. The tenant's consent. In some cities, landlords may increase rent under certain circumstances only if the tenant voluntarily agrees to the increase or don't protest it. So it's set by the rent control board, maybe a fixed percentage, a percentage tied to local or national CPI or tenant's household income. Word of caution: even if you are otherwise entitled to raise rent, the rent board may be able to deny you permission if you have adequately repaired and maintained your rental units. Haven't adequately repaired and maintained your rental units. Rent increases when a tenant moves. In many areas, landlords may raise rent either as much as they want or by specified percentage. When a tenant moves out and a new one moves in, or when a tenant renews a lease, this feature, called vacancy decontrol, vacancy rent ceiling adjustment, or similar term, is built into many local ordinances. In practice, it means that rent control applies to a particular rental unit only as long as a particular tenant or tenants stays there. If that tenant voluntarily leaves, or in some cases is evicted for illegal or just cause discussed below, the rental unit is subject to rent control again after the new and presumably higher rent is established. There's an example. Marla has lived in Edward's apartment building for the last 7 years. During that time, Edward has been permitted to raise the rent only by the modest amount authorized by the local rent board each year. Meanwhile, the market value of the apartment has gone up significantly. When Marla finally moves out, Edward is free to charge the next tenant the market rate, but once set, that tenant's rent will also be subject to the rent control rules. In some cities, no rent increase is allowed at all, even when a tenant moves out. Check your ordinance. Legal or just cause, and that's probably just New York. Legal or just cause evictions. For rent control to work, it must place some restrictions on evictions. Otherwise, landlords who wanted to create a vacancy so they could raise the rent would be free to throw out tenants, undermining the whole system. So many local ordinances require landlords to have a legal or just cause, that is, a good reason to evict. Just cause is usually limited to a few reasons provided in the ordinance. If you really need to evict a tenant, you should have no problem finding a reason for on the approved list. Here are a few typical examples of legal or just cause to evict a tenant. The tenant violates the lease or rental agreement, for example, by failing to pay rent or causing substantial damage to the premises. So those are 3 reasons right there. Violates terms, failing to pay rent, substantial damage. The landlord wants to move into the rental unit or give it to an immediate family member. The landlord wants to substantially remodel the property, which requires a tenant to move out. The tenant creates a nuisance, for example, by disturbing other tenants or engaging in illegal activity on the premises. Now, registration of rentals. Some rent control ordinances require landlords to register their properties with the local rent control agency. This allows the rent board to keep track of the city's rental units, and the registration fees provide operational funds. Deposits and notice requirements. Rent control ordinances may impose rules regarding the amount of security deposits and the type of notice you must give tenants when you want to raise the rent or terminate the tenancy. The requirements of these local ordinances are in addition to any state law requirements. For example, state law may require a 30-day notice for a rent increase. A local rent control law might also require a notice to tell the tenant that the rent control board can verify that the new rental amount is legal under the ordinance. And where to get information about rent control. Your city rent control board, it can supply you with a copy of the current local ordinance and possibly also with a brochure explaining the ordinance. Check your phone book for the address and phone number of your local rent control board, or contact your mayor or city manager's office. Your state or local apartment owners association. In New York City, owners of rent stabilized apartments are required to join a real estate industry association called the Rent Stabilization Association of NYC. It gives members information on on rent matters and help on rent matters and offers mediation for tenants' complaints. Local attorneys who specialize in landlord-tenant law. Check out the yellow pages or Ask Another Landlord, Chapter 17, Section A. 6 is how to find and work with a lawyer. So the next section is when rent is due, but we have enough from this section and are going to probably move on to a different section in a different recording.